The Supreme Court hears two cases challenging laws in Idaho and West Virginia that bar transgender athletes from participating in girls' and women's sports. Arguments that could affect 25 other states that have similar policies, as well as the High Court's jurisprudence on the 14th Amendment and Title IX.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues on the Journal's opinion pages, Nicole Alt and Kim Strassel. 27 states have now enacted laws or policies that forbid biological males from joining girls' sports teams. But at least two of those states have now lost appeals in the circuit courts to transgender athletes seeking exemptions from those policies. One of these cases is brought by BPJ, a West Virginia cross-country and track athlete. The other, the case from Idaho, is brought by Lindsay Hecox, who tried out for college track and cross-country sports at Boise State University and played in the club soccer team. Nicole, maybe the place to start is give us a sense of how these laws are structured and how they operate.
Yeah, so these laws, as you mentioned, 27 states have passed laws or policies like this that segregate sports based on biological sex. So, and that's defined as how, whether you're born male or female. And they forbid biological males from playing on women's teams, but they do not forbid biological females from playing on men's teams. And the purpose that these states have in doing that is to protect women because they generally have a physical disadvantage to men.
So to underline that point, male sports teams are open to everybody still, even in these states. So if you're a girl and you want to be on the wrestling team in elementary school or the football team, that is still permitted. West Virginia, right, in its brief, specifically says that this law that it passed was focused on the safety of women competitors. So, Kim, part of the legal argument today at the Supreme Court is focusing on whether this is an as-applied challenge. So this is not a challenge to the existence of these laws generally as applied to many athletes. It is a request, essentially, for the ability to get exemptions from them. Let's start with a clip of Justice Samuel Alito tangling with the attorney for Lindsay Hecox.
All right, suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
So you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman.
I think
is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team?
So, Kim, to my mind, the important thing to understand here is these are challenges to these laws as applied to these two individual athletes who, by the way, deny that there is any advantage as athletes that they have enjoyed. So the briefs for Lindsay Hecox, for example, focus on the idea of testosterone as the advantage, the athletic advantage that males enjoy. And so suggests that transgender athletes whose testosterone is suppressed do not have any advantage. BPJ has been on puberty blockers The brief in that case says that BPJ never went through male puberty and has been on a type of estrogen since about the end of 6th grade. And notably, Kim, the states obviously dispute this and say that even prepubescent males have a athletic advantage, citing statistics saying that they run farther and they do more sit-ups on timed sit-up tests. So part of what makes this tricky is that even at the Supreme Court, even as we reach this oral argument at the Supreme Court, the two sides are actually disputing the facts and what the science really show.
To your point about an as-applied challenge, that is somewhat central to those who are bringing the case. And it's an interesting aspect that both sides do seem to agree on one thing. They have both been in court arguing that the number of individuals in question here, those who identify as transgender and also seek to play in girls' and women's sports, is quite small. And it's actually hard to actually know what those numbers are. Charlie Baker, the president of the National Collegiate Athletic Association, said there were fewer than 10 trans athletes competing out of more than 500,000 students playing college sports. But we don't know how many trans girls and women are playing sports at the K-12 level or in recreational programs, et cetera. But the reasons that both of these sides are making this case is, on the one side, the advocates of these two particular plaintiffs argue that this is getting way too much attention. There's no need for a sweeping rule. This should be, decided on a case-by-case basis. And look at our particular plaintiffs. They have reasons why they should be allowed to continue to play in these sports. Those in support of the laws argue that, in fact, because there are so few people out there, the laws should just be able to stand as a bright line because it really isn't harming any enormous number of people. Then this gets into the question of what the science knows. Idaho is arguing that, male athletic advantages begin before puberty. They have cited figures that average boys age 9 to 10 at the 50th percentile already are able to do far more than equivalent biological females at the same age. There's also some really good evidence presented in these cases that the individuals in question certainly seem to have a competitive advantage, especially the West Virginia case. There's a brief filed by a girl who competed alongside BPJ. She ended up being bumped out of a state tournament. And after BPJ consistently, despite being younger, outdid all her records. And then BPJ went on to place 3rd in the state in discus and 8th in the shot put. And the state is putting this forward. There's still some unknowns out there in terms of the science. But this is an interesting thing because the question of as applied or not is likely to be very central to what the justices decide in the end. We can get into that when we talk about Title IX and the Equal Protection Clause and scrutiny, but those are likely to be what this hinges on in the case.
On the point about the small numbers of transgender athletes involved here, the United States Deputy Solicitor General had also participated in the oral argument. Here is part of what he said in his opening.
It is undisputed that states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same.
So the point there, Nicole, is he's arguing that even if there are some small number of athletes for whom the general rule does not seem to apply, if the general rule is upheld by the Supreme Court, that's good enough legally. And the challenges here, some of them at least, are under the 14th Amendment, which promises the equal protection of the laws. And there is some history here at the Supreme Court about how you evaluate laws that classify based on sex, and they are subject to intermediate scrutiny. So it is not the strict scrutiny that is very difficult for a law to pass. It's a lower standard based on what the Supreme Court has recognized are real biological differences between men and women.
Right. There are differences between the sexes. And so unlike race, there are cases where it's valid for a law to make distinctions between them, which is why they're subject to intermediate scrutiny and not strict scrutiny. And so the states are arguing in this case that the laws should be evaluated under intermediate scrutiny, and that they pass that test, which is basically that the state has to have a substantial interest in what they're trying to enact, and that they have the means that they choose to do that are reasonable or reasonably tailored. And they're arguing, separating sports teams by biological sex makes a lot of sense. If you don't do it by biological sex, how are you going to separate them in a way that protects women? Are you going to evaluate hormone levels or just based on gender identity, or their biological sex makes the most sense? And so they're arguing that even if the law, of course, there will be exceptions where you'll have a male who isn't as good as the girl on the team, but that can be true no matter whether that athlete is transgender or not. And if you were to account for all these exceptions, you really couldn't have men's and women's sports teams based on sex.
The states are raising an administrability problem if these as-applied challenges are allowed to go forward, Kim. Let's listen to the Idaho Solicitor General tangling here with Justice Ketanji Brown Jackson.
Making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring, because circulating testosterone can fluctuate. That is invasive. That is intrusive.
Yeah, that's the burden of the person. The person who wants to play, he has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
And Kim, if the general rule of these states that we have girls' sports and they're reserved for biological girls, if that is not upheld with respect to these as-applied challenges, then the question I find myself wondering is, who is going to decide all of these individual cases as they come up? I mean, just to pick on a couple of things, you heard the Idaho Solicitor General talking about how are we supposed to figure out whether any individual transgender athlete may have a biological advantage over the girls that he is competing against. Are we supposed to do, invasive hormone testing? And what if medical plans, medical treatments change? How often are we supposed to do that? And then there's also a question about which sports would that apply to. So the briefs in these two cases point out that they're talking about cross country and track athletes. And so those are non-contact sports. But it's not hard to imagine the next case that might come up might involve a volleyball player or a basketball player. And who is going to make that call of, how much contact, how much jostling on the court in a sport like basketball or soccer is enough to justify the real safety concerns that the states are citing as the real rationale for this law. I mean, I can only imagine that if it's a 14th Amendment claim, are individual district court judges going to be deciding yes on basketball, no on volleyball, yes on cross country, no on soccer? I just don't see quite how that is supposed to work.
Yeah, it'd be an absolute mess. And you just laid out some of those. Another one that I would add in there, just because we heard Justice Ketanji Brown Jackson bring up the term. She said, it would be up to the individual to submit to these things to make sure they didn't have a competitive advantage. What then counts as the evolving or non-evolving standard of a competitive advantage, right? If you are, I can just imagine the tables out there of saying, well, you operated in the 50% realm compared to this cohort of people who were the same age and weighed the same amount than you did. I mean, it's really opening a Pandora's box. And I think that is part of the allure of those in this case that are arguing on behalf of the state laws, is that it's a lot cleaner. It's a bright line distinction. And that is something that is always a little bit more attractive to the justices, because they recognize the risk of putting out muddy opinions that end up sending these cases straight back up to them, and only after decades of a lot of confusion in the lower courts. Clarity is always good. I mean, I think that is one of the things that is actually working on behalf of those supporting the laws, is that this is a bright line distinction. The challenge laws here, which define who may play in girls and women's sports, do so very clearly, very distinctly on the basis of sex, not on the basis of gender identity. And so the important point to make here, which works against those who are opposing the laws, is these are not discriminating on the basis of gender identity. They're disregarding gender identity. I mean, these laws essentially say boys can't play on girls' team. And by the way, that's true both for boys who identify as male and boys who identify as female. And there's a reason for it. Here's why. To go into anything else makes it way too complicated. To do it on an as applied basis with exceptions opens up a mess of litigation. Let's stick to this. And I think that my view is that the justices are going to be very tempted to go down that road and that reasoning.
And Nicole, another of the arguments that is raised in the BPJ case, and this is the one that the Fourth Circuit ruled against West Virginia on, is Title IX. And a little bit of focus on Title IX by Justice Brett Kavanaugh, a noted girls basketball coach in his personal life. I mean, he suggested that Title IX is responsible, at least a lot of people see it that way, for huge strides in recent decades in girls' sports. The Journal's editorial on these two cases suggests that accepting the Fourth Circuit's argument that BPJ was subject to discrimination under Title IX would turn Title IX on its head. So talk a little bit about what Title IX is and how it relates to these two claims.
Yeah, so Title IX was enacted in 1972, banning sex discrimination in federally funded education programs. And part of the intent of it was to protect women's athletic opportunities, and it's implementing regulations allow for sex distinctions or sex separated sports and facilities. It's not saying that it's not sex discrimination, or banning sex discrimination doesn't mean banning sex distinctions, and Title IX is clear about that. And so in this case, one thing that's come up is the Supreme Court's Bostock ruling from a few years ago, in which they applied the ban on sex discrimination under Title VII, which covers employment law, also applied to gender identity or transgender status. And the Fourth Circuit applied Bostock here and said that BPJ was being discriminated against in violation of Title IX.
Notable that the dissenters in that Bostock ruling warned that this might be the next step, that the Bostock decision might be taken by plaintiffs into women's sports and women's locker rooms. Kim, there's also a reverse argument if I understood the representative of the Solicitor General's office in the oral argument today, I understood him. I heard him, I think, say that the Trump administration has argued that permitting transgender athletes into women's sports is actually the Title IX violation, denying under Title IX women and girls spaces for women and girls. And notable, there's a brief, an amicus brief in this BPJ case by a teammate referred to in the brief as AC. AC apparently has been bumped down the rankings by the participation of BPJ, but also suggests that BPJ has made comments and sexual bullying, it says, in the locker room. So here's a line from the brief. The comments ranged from BPJ telling AC she had a, quote, nice butt, to remarks so vulgar that merely repeating them is incredibly embarrassing to AC. And my understanding is that BPJ has denied making those comments, but just, for the sake of the argument on what Title IX really is supposed to mean in terms of, protecting spaces for girls' athletics, but also for girls in locker rooms and so forth, it seems like that's part of the debate.
Yeah, we've talked about now some of the science is being disputed here, the legal aspects that are being disputed. But the broader reality of Title IX in its intention, and obviously that's something that matters deeply to the justices, is the idea behind the creation of statutes, what went into them. And it was clearly designed to help women in sports, to give them their own facilities, their own places to play in an area of sort of safety and freedom and happiness. And when you read that brief, which is very affecting, and I would suggest if you're going to go read something in this case, that is one worthwhile doing, this brief offered by AC, who is a teammate of BPJ. Very detailed explanations of the emotional distress that AC felt at having to change in a locker room or a bathroom alongside a biological male, fears of going to tournaments because often the teammates will room together in hotel rooms, and the fears that some had with having to room overnight with a biological male. Obviously, those comments that were made that whether or not they're in dispute, the reality is that comments could like that be made. And it is something that needs to be considered in all of this. I mean, we, as you know, Kyle, when Bostock was decided, we very clearly pointed out that it was going to create a bit of a mess. And here we are. It's now in the locker room, as it were, the women's locker room. One thing that I think is useful is that with the chief joined Bostock, but he later sort of has been involved in some other cases that has tried to dial that back a little bit or cabinet some. One thing that he has pointed out is that Bostock was never necessarily meant to apply outside of the workplace. That certainly seems to be an interesting tack, and you're hearing some of the justices bring that up here now. There's also this question of rational basis review, as you were mentioning, different levels of scrutiny, and whether or not in this case, the argument won't just be that these state laws that they should be treated as having common sense rationale behind them, and therefore not subject to higher scrutiny, as it were. So I think that there's some ways that they can negotiate around some prior cases. But the Title IX thing, it could well be that the litigation here isn't over no matter what this case decides, because there may be some that demand an even clearer ruling from the Supreme Court about the sanctity of Title IX, as it were, as it relates to women athletes.
Thank you, Kim and Nicole. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.